Hi everyone, my name is Rachel Marks and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Alex Barthet, a Florida construction lien law guru. Today's webinar's topic is Florida's lien law just changed. Are you ready? So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thank you very much, Rachel. My name is Alex Barthet. I am a board certified construction attorney here in Florida. And today we're going to talk about the changes that were just made by the governor to the Florida Lien Law. So let's get started. If you have any questions, go ahead and use the GoToWebinar chat box, which should be on your screen. We will answer all the questions at the end, but submit them as you think of them. Please do not include the names of any people or companies in your questions. So what are we going to talk about today? We're going to talk about when do these changes go into effect. We'll talk about some changes to certain definitions in the lien law. We'll talk about how to calculate holidays and weekends, which was slightly clarified in the statute. Mobile home liens were one of the major changes in the statute. We'll talk about that. We'll talk about terminating notices of commencement and discharging liens, also clarifications with this new law. And we'll talk about private project notices of non-payment. Those are bond claims on private jobs, lien transfer bonds, and public project notices of non-payment, and all the changes that were made to those statutes with this new set of changes by the governor. And as always, we'll answer any questions you have at the end. So when do these changes go into effect? The effective date of these changes is October 1st, 2023. So in a few months. You'll notice that many of the changes that we go through, and by the way, we will be talking about all of the changes that are made. There really are no other substantive changes than the ones we're going to talk about. They all go into effect on October 1st, 2023. And these changes, again, you'll notice are rather procedural, kind of tightening up around the edges on various issues. Nothing really earth-shattering as far as dates or notices that have to be given. So let's talk about the changes to the definitions. There are two major changes to the definitions. So the first is the definition of what a contractor is, and it's now been updated to include specifically construction management. So the term contractor also includes a licensed general contractor or building contractor, as those terms are defined in Chapter 489, who provides construction management services, which includes scheduling and coordinating pre-construction and construction phases for the construction project, or who provides program management services, which includes schedule control, cost control, and coordinating the provision or procurement of planning, design, and construction of the construction project. Now, where I see an issue with this new addition is what happens if you're a contractor and you start, let's call it pre-con services, right, which would include scheduling and coordinating pre-construction services, but the project never takes off. Do you have lien rights? You never perform any actual work on the project. Do you have lien rights? It's a little unclear, but I think the inclusion of that last phrase and construction for the construction project would lead me to believe that you still have to do some work. Something has to happen on the construction project. You may not be the one doing it yourself, because you may just be doing cost control or other construction management services as a licensed general contractor. And that's another key point. You have to be a licensed general contractor to do this. But I think construction of the construction project, at least in some form, has to happen for you to have lien rights. But again, it's a little unclear in the current edition of this construction management definition to contractor. The second definition change is how they define final furnishing of materials. So the first part that I'll read is the current state of the statute. It's the bold section that is new. So final furnishing means the last day that the lienor furnishes labor, services, or materials. Such date may not be measured by other standards such as the issuance of certificate of occupancy or the issuance of certificate of final completion, and does not include the correction of deficiencies in the lienor's previously performed work or material supplied. With respect to rental equipment, the term means the date that the rental equipment was last on the site of improvement and available for use. It's the inclusion of the last, was last on the site of improvement, meaning that I believe in order to determine when you have lien rights for rental equipment, it would both need to be on the site of the improvement and available for use to be lienable. There was some distinction in the past on whether or not your material needed to be on the site in order for it to be lienable. Now it's clear that if it's not on the site of the improvement, then it is not lienable with respect to rental equipment. And there is one other definition change, and that's the inclusion of a new definition for finance charges. A finance charge means a contractually specified additional amount to be paid by the obligor on any balance that remains unpaid by the due date set forth in the credit agreement or other contract. Now, there was an existing case that came out a few years ago that tried to distinguish between interest and finance charges, and the end result of that case was that a lienor was not entitled to recover interest or finance charges. They had a distinction in the name, but what we consider them to be interchangeable on an amount due. So the example that I can give you would be, let's say you're a material supplier to a subcontractor and you make a bond claim on a project and you haven't been paid for 6 months. Now, under your agreement with your customer, you're entitled to 18% interest. That's in your written credit agreement. Now, the surety comes and says, okay, we'll pay you because your rental equipment or supplies were on the project, but we don't have to pay you your finance charges. Well, finance charges on at 18% and even 6%, 12% can add up on a big number. And the current state of the law is that those amounts were not recoverable. Those finance charges, because you didn't have a direct agreement with the surety to pay finance charges, and the case that I'm talking about said that they were not recoverable. So the inclusion of this definition makes it clear that finance charges are 100% recoverable as part of your lien amount. So the next change, calculating holidays and weekends. Now, this statutory change clarifies what the existing state of the law is, meaning that the law, based on the cases, says what the statute now says. So they took the current state of the law and they put it in the statute. So let's talk about holidays and weekends. In computing any time period under this part, if the last day of the time period is a Saturday, Sunday, or holiday, or any day observed as a holiday by the clerk's office or designated as a holiday by the chief judge of the circuit, the time period is extended to the end of the next business day. So that just means that if the holiday happened on a weekend, your last day landed on a weekend or holiday, you roll the notice to owner and claim of lien and notice of non-payment deadlines accordingly. Now, we have an app at the Lien Zone. If you have an iPhone, you can shine your camera at this QR code, and you can download our app. This app has many features, but one of them is called the CalcuLien, and it will calculate the notice to owner, lien, and bond deadlines, and it will include standard legal holidays. So for example, it will automatically know if your 90th day on a lien landed on a Saturday, so it would roll to the Monday. And if Monday was a holiday, it'll move it and it will calculate all of that for you. So again, if you have an iPhone, you can go to the lienzoneapp.com or scan the QR code. We have not forgotten about those Android users. So we have an Android version of the app as well. Again, you can get this app at the lienzoneapp.com. And you can download it from the app stores to calculate your notice to owner, lien, and bond deadlines. Now, the pandemic also caused the legislature to add in a section to cover situations where the office is closed for unexpected issues. So now it says if the clerk's office is closed in response to an emergency for 1 or more days so that a person may not present a document for recording or an action for filing in person with the clerk staff, the time period for recording a document or filing an action with the clerk's office under this part is told. When the clerk's office reopens, the time period is extended to the end of the business day that equates to the number of days the clerk's office was closed. So hurricane, the next pandemic. But what's interesting is when you read this, it doesn't say that it adds it to the end of the, that it only applies to the time when you are at the end of the period. So what happens if you're at day 40 on your 90 days on a lien, the clerk's office is closed for 4 days because of a hurricane in the middle of your 90-day period, and then now it comes time to record your lien. Do you record it on the 90th day? Or do you actually get 4 more days because in that 90-day period, the clerk's office was closed for a holiday, for an emergency, for a hurricane or some other issue? I don't have an answer. The statute is not clear in that regard. I would tell you that the best thing to do is make sure you record it well before the 90 days so we don't have to have this argument. But if by some chance you're late, maybe you can look back and see, oh, look, the clerk's office was closed for 3 days because they had a flood or there was a hurricane in that county. Something to keep in mind. Mobile home liens. This was the major change in the statute. Again, if you don't deal with mobile homes, it probably doesn't matter. But what it does is it makes clear that the landlord that rents their property to a mobile home owner, their property is not subject to lien. So it says the interest of the lessor, the landlord, is not subject to liens for improvements made by the lessee, the tenant, when the lessee is a mobile home owner who is leasing a mobile home lot in a mobile home park from the lessor landlord. So if you're doing work on a mobile home for a mobile home owner that doesn't own the land that the mobile home is on, just know that your lien only attaches to the mobile home. It does not attach to the land that the mobile home sits on. Terminating notices of commencement. Normally, liens must be recorded within 90 days of your last work. However, if a notice of commencement is terminated, then you must record your lien within 30 days of the date of termination. That is the current state of the law. And that is listed in this subsection. Again, nothing new. There's nothing new here with respect to the fact that if a notice of termination is served upon you as the lienor, you no longer have 90 days to record your lien. You only have 30 days from the date that the notice of termination was recorded. But what if you did not get a notice that the notice of commencement was terminated because maybe you didn't send a notice to owner yet, meaning you happen to show up on the job late, such that your 45 days to serve your notice to owner hasn't finished, but they've already terminated the notice of commencement. And that's where the new law clarifies the issue. And it says, however, if a lienor who began work under a notice of commencement before its termination lacks a direct contract with the owner, so that would mean you're a subcontractor or a supplier to a sub, and you timely serve your notice to owner after the notice of termination has been recorded. So again, remember, you show up on the job, you just got hired, you show up, you don't know that the notice of commencement is being terminated. You go ahead and serve your notice to owner normally, as you normally would. Now the owner must serve a copy of the notice of termination upon the lienor, and the termination of the notice of commencement is effective 30 days after the service of the notice of termination. So if you fall in that little window because you showed up really close to when the notice of termination happened, once the notice to owner is received by the owner, they now have an obligation to serve the notice of termination on you. And the moment that it's served on you, now you have 30 days to record your lien for any work you did in that period. And also remember, you need to serve a new notice to owner for the work related to the work after the notice of termination. So that's how you're going to protect yourself if you fall in that little window. So discharging liens. There are a few ways to discharge your lien. You can do it by recording a satisfaction. The court can order your lien discharged, or you fail to timely file a notice that's required under the lien statute. The law now clarifies that a termination, specifically a termination by recording a satisfaction, can be done in whole or in part. That's something that has been done in practice for many, many years, where you will partially satisfy a lien. But there's a handful of cases that suggested that that was improper. So the legislature clarified that you can partially satisfy a lien. You don't have to fully satisfy the lien. Again, something that practitioners were doing for a long, long time already. The statute also added that any satisfaction or release must be notarized, has to have the official reference, the official records reference number, and the recording date affixed to the document itself, that's referencing the lien that it is satisfying. And the reason for this is the clerk needs to know, and title agents need to know, well, if you've recorded this satisfaction, what lien is it satisfying? So you have to include all of this information in your partial satisfactions going forward, and final satisfactions. We also have another tool on the lien zone. It is a stamp called the Make Me Conditional stamp. We'll send it to you for free. Just go to thelienzone.com, or you can scan this QR code, because in addition to the changes in the law, it's always great practice to only send conditional releases that are conditioned on you actually receiving payment. And the best way to do that is to put in conditional language. And if you have any doubt, we can send you the stamp, you stamp it, and it says, notwithstanding anything to the contrary, this waiver and release is conditioned upon and not effective until the undersigned receives paid funds of. So if you're expecting a $28,000 check, you'll write that in the blank. And then you can put this on your releases, and you'll know that every release that you send with this stamp is conditioned on that payment. Okay, just a few more slides here. Private project notices of non-payment. Those that are in privity with the contractor, that means those that are in direct contract with the contractor, must serve a copy of the notice of non-payment on both the contractor and the surety. That was not clear in the prior version of the statute. You previously only had to send it on to the contractor, but now on private projects, that notice of non-payment must be served on both the contractor and the surety. Again, for those of you that use SunRay, they're sending it to both already as a belt and suspenders. It's great practice to do it, and now come October, it's going to be mandatory. Also, those in privity with the contractor, So those not in privity with the contractor must serve the notice of non-payment on both the contractor and the surety, and those in privity with the contractor must also serve the notice of non-payment on both the contractor and the surety. Again, our recommendation is make sure you serve it on the people that are going to potentially be writing you the check. So that's going to be the contractor and the surety. So the law makes it very clear that those parties, both the contractor and the surety, need to get a copy of your notice of non-payment. Lien transfer bonds was slightly modified. When a lien is transferred to a security bond, when the clerk calculates the value of that bond, they are now required to use the greater of either $5,000 as opposed to $1,000 or 25% of the value of the lien to account for potential attorney's fees in the calculation of the bond. So that was the change. It went from $1,000 to $5,000 as the minimum. Now the clerk's office is also required to serve a copy of the transfer certificate and a copy of the deposit for a cash bond or the surety bond supporting the transfer. This is important because when we would help clients that had liens transferred to bond, sometimes all we would get would be the transfer certificate. And that transfer certificate was not always complete in the information it provided. So sometimes it was hard to figure out who we had to file a lawsuit against because that transfer certificate didn't disclose who the surety bond was. So then we would have to go get a copy of the bond. Now it's required that when the lien is transferred to bond, the clerk has to send the certificate of transfer and a copy of the bond. Those are two things you should now be receiving going forward when your lien is transferred to a bond. Finally, public project notices of non-payment. Language is added to allow a claimant to serve a notice of intent to look to the bond, a notice of non-payment, for protection 45 days after the claimant is served with a copy of the bond if the bond is not recorded before commencement of the work or before recommencing the work after a default. So what does this clarify? It clarifies that a notice of non-payment must be served on the contractor with a copy to the surety by those people not in privity with the contractor, especially when a copy of the bond is not recorded in the public record. So the problem is that what happens if you do work on a public project and you don't know that it's bonded? You don't know who the surety is because the contractor did not record a copy of the bond. This makes it clear that you need to serve that notice within 45 days after you are given actual notice that that bond exists if it wasn't recorded. Just a little reminder that there is no notice of non-payment. No notice of non-payment is required for those who are in direct privity with the contractor on a public bonded project. So if you are the plumber to the bonded contractor, the plumbing subcontractor to the bonded contractor on a public bonded project, you do not need to serve a notice of non-payment. I still think you should, but it is not a required item in order to perfect your lien rights. Okay, Rachel, that's the end of the presentation. Do you have any questions for me?
Yes, we do have a couple questions here. So the first one, I need to know what are my options if the NTO was never filed and the contractor is not providing payment?
Okay, that's a complicated question. So the first thing I would say is it really is fact dependent on your situation. So you see my email address there. It's probably best you email me because your situation may be unique. But at a high level, the first thing we would do is we would determine, was a notice to owner required? Is there some exception in the lien law that would give you lien or bond rights even in the absence of a notice to owner? And there are several that could apply. So that would be the first analysis we would do. if we determine that turning over every rock, we cannot find a situation in which no notice to owner is needed, then your options would be primarily to file a lawsuit against the contractor, whoever you have a contract with, to get paid, that they still have potentially an obligation to pay you even if you don't have lien rights. The first thing we would look in that regard, though, would be to see, is your contract with the contractor or subcontractor, I don't know where they fall in the chain of contracts, is there a pay when paid provision? Because maybe there is a pay when paid provision that is enforceable. And again, maybe it's not enforceable. We can also look for that, so that we would determine, do you have rights to sue the person that hired you? At a high level, that's what we would do. But again, send me an email. I'm happy to go into more details with you on your specific situation. What's next?
Okay. What if there isn't a surety because bonds were not required?
So on private jobs, you would have lien rights if there was no bond. So you would have to perfect your lien rights in order to secure a lien on the property. If the job is a public project where there are no lien rights, and your only right is a right against the contractor's bond, and if there was no bond on the public project, your only recourse would be to sue the party that hired you. Very similar to the last situation. Again, there are thresholds that a public entity needs to follow in order to determine whether or not the project needs to be bonded. Typically, any project over $400,000 for a state, county, or city project has to be bonded. Over 200,000, it's at their discretion, and under 200,000, they don't need to have it bonded, and usually they don't. What's next?
Okay. Would you recommend using the conditional stamp for all states or just for the state of Florida?
So I'm only licensed in the state of Florida, so I don't know the impact on that, the use of that stamp in, Georgia, Texas, New York. I can't imagine that it hurts, right? Because it's just adding additional language to the waiver and release to make it clear that this release is conditioned on you receiving paid funds. So the non-lawyer answer is, I would do it because I don't see a downside, but you would have to check with a lawyer to see if there's some other issue in that state with respect to use of that stamp, but I doubt it.
Okay,
Anything
so
else?
next question. Do you have a recommendation for how to properly list exemptions, such as pending change orders on a partial release of lien?
Yeah, it's actually very easy. All you need to do is say, uh, this release excludes, and then list whatever you want. You want to list all of your pending change orders, any claims that you have. You would list those right after you say those few words. If it's a long list, maybe you want to attach a separate exhibit. So you would say this release does not include those items listed on Exhibit A, and you can just list them there. I would suggest to you that the more changes you make to a release, the less likely it will be accepted. But that's all you have to do, is just include a few words to indicate that they're excluded, and then list them specifically. So you could say this release excludes, uh, PCO 7, 9, 14, and 32.
Okay, great. So those are all the questions. Oh, just kidding. Let's see. Alex, can we get a hard copy or ability to print this presentation?
Absolutely, Rachel. I think you can take care of that. I think everyone
Yeah.
normally gets the PowerPoint slides afterwards, right?
So actually, on our website, once this has been done recording, it will automatically show up on our website under Florida past webinars so that you can come back and watch it at any point. But if you would like for me to send you a PDF of the slides in this presentation, I can absolutely do that. Just go ahead and send me an email, rmarks@sunraynotice.com, and I will get a PDF over to you. Okay? Okay, so first of all, thank you so much, Alex, for your time this morning and educating us on the new Florida Lien Law changes. You provided us with super helpful and extremely valuable information. I know there are going to be a ton of happy people out there knowing that construction management is now included under the definition of contractor. So that being said, moving on, I have some very exciting news. We have heard you and we understand your needs. So that being said, we are excited to say we will be launching SunRay Commercial Collections beginning August 15th. SunRay offers a range of services that can significantly benefit your business. We have advanced technology, which is integrated with our SunRay application. For one, we are experts in the construction industry and we understand you. So we will help you recover outstanding payments and maintain your business relationships. If you would like more information on our collections company, please visit www.sunraynotice.com/collections. So if you'll go to the next slide, please, Alex. If you guys would like to take a moment to review us on Google, we would greatly appreciate that. And then the next slide. Okay, so our upcoming webinars with Alex. The surety won't pay me, how to get a bond company to pay. So that webinar is on Wednesday, August 16th from 9 a.m. to 9:20. And then the next webinar with Alex will be 3 avoidable lien release mistakes that will cost you big time. That will be on Wednesday, September 13th from 9 a.m. to 9:20. Make sure to register at sunraynotice.com/education. And our next slide. And that's all that we have. So I hope everyone has a sunny day and we hope to see you on our next webinar. Thanks so much.